Attorney Wolken?
Yes, I am, Your Honor.
Okay.
Steve Wolken,
Okay, we're waiting
representing.
for, one moment, we're waiting for apparently Jennifer Moore from the Medina County Job Family Services.
Your Honors, I'm here. I actually filed a waiver.
You did?
I did, yes,
Okay.
but the hearing that I was supposed to be at ended early, so I figured I'd come and support Mr. Wolken in his argument, but I did waive it. I told him that when he came in, that he had all 15 minutes.
Okay, great, thank you very much.
Thank you, Your Honors.
All right. Attorney Wolken, you may proceed.
Thank you. May it please the Court, Your Honors, I represent the paternal grandparents of E.G. in this case. It appears from reading the briefs and arguments that there really is no issue concerning the facts. The issue is the conclusions drawn from those facts. That's what differs between all of the parties in this case. This is an abuse, neglect, dependency complaint filed in juvenile court. It was filed on July 30th, 2015. There was a motion for legal custody filed on behalf of my clients by me thereafter. There was an adjudication on, the hearing was August 25th, 2015, but the journal entry was September 10th. There was actually a dual finding. There was a finding of abuse, excuse me, there was a finding of neglect and dependency as to the father, and there was a finding of dependency as to the mother. Father has not been a material part of this case throughout the entire process. He's been incarcerated. I'm sure upon reading the briefs you saw that there was a horrible issue concerning the death of another child, and it continues to be in jail. What occurred thereafter is a dispositional hearing took place on October 9th, 2015. At that dispositional hearing, there was an agreement that temporary custody would be placed with the Department of Jobs and Family Services. Placement was with my client's paternal grandparents. On July 29th, 2016, the county filed its motion to modify the temporary custody to place the child in legal custody of my clients. Thereafter, the matter was set for a final trial on July 14th, 2016, or 2 days of trial. Immediately before that trial, counsel for mother filed a motion to extend temporary custody by 6 months, which was pursuant to a statute that actually identifies that the county is the one that's supposed to file those things, although there is case law that indicates that a private individual can also file it. A journal entry was issued by the court after the 2 days of trial. It denied the temporary custody extension that had been requested by mother's counsel, and it granted JFS and the motion of the grandparents for legal custody of the child. This appeal was filed thereafter. As an aside, appellant filed their brief. They identified that the case was a permanent custody case, which is not. It's a legal custody case, and that does make a significant difference in both the burden of proof and in what mother may file subsequently, which is she retains residual rights and therefore can file motions to modify the legal custody at some time in the future if she so desires. The history in this case reflects that mother has been non-compliant with case plans. She has failed drug tests. She suffered from substance abuse and mental health issues. The question becomes whether or not there is sufficient evidence to affirm the trial court in this case. The recent history of mother reflects that she was divorced from father. Upon her divorce, she and a son by a different man moved out of the state, and she wasn't in contact with this child for some period of time. She was engaged while ending up in Dunkirk, New York, by way of New York City. She was engaged in some mental health services, and that basically is the basis for this appeal, is that she did engage in some mental health services and had some clean drug tests for about 6 months at the time of the trial of this thing. So based upon that, counsel for mother indicates that she was compliant with the case plan, and therefore there should have been an extension of temporary custody. I think it's necessary to look at the entire gambit of the testimony that was taken in this case. And if you look at all of that testimony, you will see that mother has an ongoing, continuous, and serious mental health problem. She and father both have drug problems. Those things don't go away quickly. And in this case, you can see by the testimony they extended over years. Paternal grandfather's testimony was that this child had had 9 or 10 residences prior to this final residence with the paternal grandparents. Everyone in this case, from the guardian ad litem to Dr. Tenner to Becky Crookston, the therapist for the child, all indicate that it's necessary to have stability. If you look at the case law that's been issued by this court, it identifies that stability is a good reason to grant legal custody to a relative in a case, if that stability exists in that particular household. And there is instability in the parent's household. I don't know how much more evidence you could need to show instability in the parent's household. There is a plethora of evidence that identifies all of the issues that existed. For starting, if you don't want to go back into the Cuyahoga County cases, or you don't want to go back to the New York cases, let's just start in Medina County. When father moved here, they opened a case. Thereafter, mother was not involved with the child until she learned of the death of the second child. After that, mother becomes involved, but if you look at the testimony, how involved was she? What did the testimony of the teacher of the child indicate? It indicated that mother had never been in contact with her. Mother never contacted her by phone, never went over there to talk to her, nothing. Mother is wrapped up in mother's own existence.
At this time, was mother in New York and the child in Medina, though?
That's correct.
Okay. So no telephone contact?
There was no telephone contact until the court ordered contact between my clients making the phone call to mother. Those calls after that, most of them went through. Mother fell asleep and missed one, did some other unusual stuff, but most of them went okay. The issue in the telephone calls, and there's always an issue, no matter what it is you're talking about, there's an issue. The issue in the telephone calls was boundaries. Mother...
Wasn't there testimony that there was a good relationship between mom and the child?
Yes, and the guardian ad litem said that. So did the social worker. There is a good relationship. All that means is permanent custody shouldn't be awarded. That's what that means. That doesn't give you the conclusion that counsel for mother believes should occur in this case.
Seems inconsistent with having no contact with the child is what's going through my mind.
I'm not sure I understand what you mean.
Well, you made a point that there was no contact between
There was.
mom.
After the divorce, there was no contact between mother and child. I don't know why. The question was never asked. I'm not going to assume why. For whatever reason, I know that she went to New York. She testified to that in New York City after living in Cuyahoga County. From New York City, she went to, I think it was Dunkirk. And then I think Fredonia, and she testified she was moving again after that. So even in the context of the short time of this case, and it is a relatively short time, mom had moved 2 or 3 times. So again, no stability. And that appears to be the factor that the therapist, as well as the judge, seized upon as being the major reason why legal custody shouldn't go to mom, but should go to the paternal grandparents.
So, Attorney Walker, when you're talking about boundaries, you're talking about inappropriate or not really appropriate things that the mother should be saying to the child during these telephone calls?
Yes, what she was indicating was she had no ability to control herself in speaking about what the future would hold. For children, this is a problem. It's different with adults, but with children, when you say, "Oh, you're going to be coming to live with me," that means something to the kid more than it would mean to an adult who hears something like that. She was saying stuff like that. You're going to be coming to stay with me. I'm going to be there in 2 weeks. Things like that, none of which were accurate. And she was told not to do it.
Had mom been advised as to what the boundaries were supposed to be during those phone calls?
on multiple occasions. Testimony of a social worker indicated that he had told her. The testimony of Becky Crookston indicated that by telephone she told her. My clients told her. So on multiple occasions she was told, and she has no ability to grasp it, to take it in, to apply it to what she's saying, what the child's saying to her at the time. It's simply a problem that she has. She can't properly identify what she should be doing and what she shouldn't be doing. One of the diagnoses was narcissistic disorder. That's one of the problems of a narcissist. Everything relates to them. It doesn't relate to anyone else. You can't identify with your child or other person. That's what narcissism is.
Was there any evidence in the record at all that it's in this child's best interest to reunify with mom?
I think counsel for mother would say yes, and he would point to the fact that there's a good relationship with the child, and I think he would point to the fact that mom had 6 months of clean urines, and that mom was in fact going to therapy. But you have to look at more than that. Look at the therapy. The letter from the therapist, her own therapist, says, well, we're trying to work on these issues related to her disorders, but every time she comes in, we spend an hour dealing with a crisis that she has. It's the way she is. She presents in a crisis mode no matter where she is. So you have to deal with that, and by the time you're done with that, an hour has gone by, and how can you get to what the underlying basis of these issues are?
So she was not making progress on dealing with these mental health issues?
That's correct. That's correct. I'm not a doctor. I'm not a psychologist. Would medication help that? Would constant therapy help that? I don't know. All I know is that
that was her therapist's opinion.
that was her own therapist writing a letter to I believe it was the social worker.
Thank you.
When reviewing the mental health history of mother, she's had numerous psychiatric admissions. She had suicidal attempts. She had homicidal ideation. In addition, Dr. Tenner identified that she'd had numerous diagnoses over time. Major depressive disorder with psychotic features, schizoaffective disorder, substance-induced psychotic disorder, borderline personality disorder, continuous drug usage. Dr. Tenner herself diagnosed histrionic personality disorder and narcissistic personality disorder, as well as bipolar disorder. It's a hodgepodge of her symptoms that come to these conclusions for the doctors. It was interesting to note, at least I found it interesting when reading Dr. Tenner's report, that Dr. Tenner could really not make heads or tails of any history for this woman. She didn't use the word lying or didn't use any kind of statement that she didn't believe what the mother was saying. She said she couldn't factually determine that anything she was saying was true. And most of it was quite outrageous. Some of it related to being basically a madam in New York to a Saudi prince, that she was in the towers at 9/11 when they were hit. And just odd stuff that she came up with during the course of her interviews with the forensic evaluator. In any event, the issue is stability. Is there stability in the life of the mother? And when you look at the whole penumbra of the diagnoses, when you look at all the facts as they exist in the transcript, I don't think you find stability. I really don't. She even testified. She knows that she has problems. She just wants to work on her case plan longer. And that was basically the argument made by her counsel. She should be given more time. This is years in the making. If ever, it will be years in dealing with it. Not 6 months, not 1 year. It will be a lengthy period of time before the mother ever gets to the point where, in my opinion, she could request that a court look at custody again. She has the right.
Could the New York home study, interstate compact study, have been accomplished in the 6 months?
In the additional 6 months?
Sure.
There would have been another one, but the answer to your question is I do not think it would have been any different. And the reason I say that is the basis upon which the New York compact came back that you shouldn't place the child here in New York, was this woman picks male companions that aren't so great as far as individuals. She picked my client's son, who's in jail. She picked another guy who, while the social worker was there on a single home visit, he got in a fight with her. She identified possible domestic violence, and he refused to cooperate, wouldn't even answer questions. On top of all of that, they tried to do a background check on this guy, and they never could get it to come back from the sheriff. I'm not sure what that means. You know, does it mean he's in a witness protection program? I don't know. But it's really odd that it didn't come back. And all of that taken together resulted in New York saying, don't place this child here.
Okay, and with that, you've come to the end of your 15 minutes.
Thank you.
Thank you for the presentation today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and at the Supreme Court. With that, the court will be adjourned until Thursday.